So very pleased to announce our next speaker, David M. Newbeck. David is a certified elder law attorney with the law firm of Myers, Newbeck, and Hulford, and he is a member of the National Elder Law Foundation. David has practiced law in Whatcom County since 2000. He is a board member of the Elvinger Service Providers and the Northwest Estate Planning Council, and he also teaches estate planning classes at Whatcom Community College. Before coming to his current law firm, David focused on human resource issues, governmental administration, and criminal prosecution as the in-house counsel for the Lumi Nation. David's going to provide tips for long-term care planning. He's going to provide an overview of different long-term care options and their potential benefits, along with details that you should know when planning your long-term care strategies. He's also going to teach you about how to navigate legal, financial, health, and housing issues in your planning efforts that may arise. We're very excited to have him here. Please join me in welcoming David Newbeck. Yes.
Great. I'm going to put that down there. Hopefully I don't knock that over in the middle of my presentation. First of all, I'd like to thank the foundation for having me here to speak today. As I was introduced, I will actually add one other detail. This is the first time I've been in the Columbia Tower in 25 years, I think. And the last time I was here, I was dressed a little differently because I was a bicycle messenger. So I was pretty familiar with the elevator system, but dressed a little differently at those times. So I will amend the introduction just a little bit. There was a very broad description of the types of things I would talk about. We could spend all day talking about how to prepare for long-term care and understanding long-term care. I am going to focus today on steps you can take with doing some estate planning and how that will work. I will focus less on the housing aspects and paying for long-term care. I can certainly try and address and touch on some of those issues, but those are a whole, like I said, we could spend all day talking about those things. I do always find that if we just have a conversation rather than me sitting up here and chattering at you, it works much better. If the mantra of your second grade teacher that said if you have a question, your neighbor probably has the exact same question. I encourage you to ask questions while I'm doing the presentation. I think it will engender a good conversation between us. So without any further ado, let me see if I can figure out how to, I think the big green button probably is the play. There. All right. So let's start by talking about some basic estate planning documents. Estate planning does not just mean how to manage your money. This is how to manage your life and your loved one's life if you shouldn't be able to manage on your own. So today we're going to focus on 5 main documents. We're going to talk about a general durable power of attorney, a power of attorney for health care, a health care directive, wills. Everybody always loves to talk about wills. We will also touch on trusts, but trusts are, again, a whole nother topic themselves, and community property agreements. For those of you who are married, that can be an important document. All right, so before we start, just a little bit of terminology here. The principal, that is the person who is executing the power of attorney or the will. They're the person who is the subject of the document. The agent or attorney in fact, that's the person who's someone who is named in a power of attorney to sort of be in charge of their affairs. Now, I understand, and I, like most of you, the most common way to refer to someone acting under a power of attorney is, oh, that person over there, that's my daughter, she's my power of attorney. Means essentially the same thing, but technically the power of attorney is the document, and the person who's acting under the power of attorney is your agent or attorney in fact. One word that often comes up in powers of attorney is the word durable. Durable means essentially that the document survives your incapacity. So one of the main uses, you might think, of a power of attorney is if you become incapacitated, then someone can take actions on your behalf. You would think all documents, all powers of attorney should always be durable. And yes, that is generally the case, but the law requires that you have some magic language in these documents, that you say they are durable and they shall survive the incapacity of the principal. These documents, this type of document, a power of attorney, has been in existence for a very long time, and lots of these concepts have carried over even from like Old English law. So there are times you could enter into a power of attorney that is not durable. You could say, for instance, if I was going on vacation and I needed somebody to sign at the closing of a house for me, I could execute a power of attorney that was only for a limited duration and had a very limited scope. In that case, it wouldn't be durable. For the general durable power of attorney, this is essentially everything except for healthcare. You can have a springing power of attorney, or it can be effective immediately. So springing means that it only becomes effective upon the disability or incapacity of the principal. So the document, you execute a power of attorney and you're perfectly capable of handling all your own affairs. And you say, well, if I should get hurt in a tragic skydiving accident and can't handle my own affairs, then my agent, whoever I've named, they will step in and they will act. That is considered a springing power of attorney. You can also make a power of attorney effective immediately. You can say, I'm signing this today, and tomorrow my agent could go out and buy a brand new car on my behalf. They could sign my name on the contract. There is no right or wrong answer. There's no right or wrong way to do this, whether it is springing or whether it is effective immediately. I'll use myself as an example and my family. I'm an only child. My mother was perfectly competent, capable, but she was really tired of dealing with insurance companies and managing all of her financial affairs, and she said, look, I'd really like you to help me out. So I'm going to execute a power of attorney that makes you effective, my agent effective immediately. She was still perfectly competent, she just wanted some help. Other people, very independent, they're like, I'm going to manage until the last possible moment, and in that case, it would be effective only on disability. So if you have a springing power of attorney, obviously the question is, how do you determine when it becomes effective, right? So typically what would happen is if someone became incapacitated or you believe they were incapacitated, you would talk to their doctor, and typically you would just attach a note from a doctor on the back that says they're incapable of handling their own affairs. And that would be sufficient for a bank or for some other institution to understand that the power of attorney is valid. I will say, I should make sure we all understand, when you sign a power of attorney, if you're the principal, the power of attorney does not remove any authority from the principal. When my mom made me her agent, it did not remove any authority from her. She could still go talk to her insurance companies and talk to financial people if she needed to. It just adds me as an additional person who can do that. Yeah?
Does your agent have to be in state?
Her question was, does your agent have to be in state? And the answer is no. Your agent can be anywhere, especially for financial purposes these days. My mother lived in Minnesota, and I was here. And so I was also her healthcare power of attorney, and so I was able to sit in on, I Skyped into doctor's appointments with her. I talked to doctors on the phone, and I could do her banking if I needed to with computers and online. It's quite easy. Now, I will say for the healthcare power of attorney, it is easier from a practical perspective to be around and in state. Just be able to go to doctor's appointments with somebody, to interface with the medical professionals. It helps to be around, but it isn't necessary. There's no rule that you have to do that. How do you execute a power of attorney? They obviously need to be written down, and you should have an agent named, your primary agent. We always like to see at least one successor agent named, so that if your primary agent cannot act, that the successor can step forward and take care of business. And they can either be witnessed or notarized. I will add at this point, however, that Washington State particularly has a preference for the documents to be notarized. The law changed a couple of years ago, and if the document is notarized, it makes it much harder for anyone to say, I'm not going to recognize this document. And you might be saying, who would say I'm not going to recognize the document? Well, not to impugn banks here, but banks are usually the biggest culprit of not wanting to recognize a document for one reason or another. And typically, just in my personal experience, the bigger the bank, the harder it is to get them to recognize it. Particularly the national banks, because we're in Washington. These are Washington documents or Washington laws. The bigger banks, U.S. Bank, Bank of America, Wells Fargo, Chase, Citibank, all these banks, they're all based usually on the East Coast someplace, or someplace not in Washington. And so they have to call back to their home office if they have any questions, whereas smaller banks around here, they're familiar with Washington laws. They typically are a little bit easier to deal with. Now, the bigger banks, they oftentimes offer great services, and there's some reasons to be with them. But from my perspective, in working with powers of attorney with the bigger banks, it can be a little bit problematic. Her question was, are credit unions easier because they're more local? I would say in my practical experience, yes. It's just easier to get an answer from, credit unions are a smaller institution generally, and if they have a question, they can call over, across the street or whatever, instead of calling back to the 82nd floor. No offense against my New York hosts here, at the 82nd floor on the Chrysler Building or wherever in New York, right? So can the principal, the person, say with dementia in this case, can they be held liable for actions that they take, right? So the context this most commonly comes up in is, say that they have received maybe a phone call from someone, a scammer, soliciting money, right? And they try and give this person money. There's not an easy way to undo things like that. If the person who is incapacitated is, say that there isn't an issue with dementia, but say that they have some other form of brain injury, and say that they are going out and running up credit all the time, like getting new credit cards, buying those, buying things. As I said earlier, the power of attorney doesn't remove any authority from the principal. And so if it becomes a problem with the principal still acting on their own behalf and creating problems, a power of attorney won't be the solution. There can be some other ways to manage it. You can freeze someone's credit. You can do things like this. But in the worst case scenario, and I do have a sort of slide that will address this earlier, if the power of attorney isn't working, the option, the end game may be to establish a guardianship. And this is what happens, a guardianship, I'll sort of jump ahead here, I'm not going to go to the slide, but a guardianship is what happens and what becomes necessary when someone doesn't have these planning documents in place. If you don't have a power of attorney in place and you're no longer competent or capable of executing one, and you've got IRAs that are in your name or bank accounts that are in your name, or there's no one there to manage, like your spouse who can make healthcare decisions, you might have to establish a guardianship through the courts. And one of the reasons that I like to say that I preach the gospel of the powers of attorney, and I lead with talking about powers of attorney. I really think they are the most important documents you can get done. I know everybody loves talking about wills, but a will doesn't matter until you're dead. And powers of attorney really matter while you're alive. And when your family is in crisis, something has happened to somebody, they're no longer capable of managing their own affairs, the last thing you want to be doing is coming to talk to me and spending time going to the courts asking that someone be appointed to manage their affairs. And I will also say that once you are in a guardianship, the courts are up in your business for the rest of your life, right? That you have to make reports to the court as the super guardian. They oversee the actual guardian. And yeah, you're making financial reports to them, and you're making status reports to them at least yearly. And it's a pain in the keister, right? And it costs money and takes time. Yeah.
Yeah, I know about a situation like that, and I think it's very unfortunate because I don't know how many people prepare for stuff like that when you have like maybe 6 to 9 children, and so the eldest wants to take over, but the eldest is not being fair with the rest of the siblings, and therefore it is creating havoc. And so I don't know what's the most appropriate term, and I'll tell you right now, yes, there are some attorneys involved right now, and so I don't know at what age is a person supposed to prepare, because this individual, the parent, has a lot of property and a lot of money to be hashed around in this particular family that's going through something like that, where the mother has been put into a home because of the dementia.
You're
Mine piggybacks to that as far as what happens when the power of attorney isn't executing things properly and they're doing. So the flip side of what this gentleman needed is a guardianship.
First off, never too young, right? You never know when things are going to go awry, right? I drove here today on I-5. I think that's the most dangerous thing I'm going to do all week, right? Never too young. You have to be an adult, and I will also say that you have to be competent to execute these documents. And I'll take a little sidestep here, talk about competency, that just because you have a diagnosis of dementia does not mean you are not competent, right? If it is early on, and competency is not a fixed point. It doesn't say you are competent here and then all of a sudden you become incompetent. And competency to execute these kinds of documents, I should say capacity, I'm using the wrong term here, capacity to execute these documents. Although we talked about the note from the doctor before, whether you can execute these documents, whether you still have the capacity to do that, that is a legal decision. A lawyer will make a judgment. It's certainly going to be informed by medical information, but a lawyer is going to make a judgment. Do you have sufficient capacity to execute powers of attorney or a will? And I will tell you that it is not always the same calculus. If someone comes to me and they have some memory impairment and they clearly have some dementia, but maybe they have one child, and that child has been a big part of their life and is already helping them manage things, that's going to be a much more natural choice, right? And I might say, yes, this person has capacity, in my opinion, to execute a power of attorney naming their child. If that same person comes to me and they want to name their new friend who they met a month ago, right? And it happens, or their caregivers, I'm going to be much more rigorous in my examination of, does this person have capacity? Are they making a decision which is not subject to undue influence, which they fully understand? And it is always good, obviously this is in my own self-interest, but it's good to go see a lawyer, right? They are the people who will understand these decisions, and it's protection for everybody. You're having an independent third party make a judgment about what's the appropriate thing to do. If you do a power of attorney, and they're certainly available on the worldwide interweb out there, if you print one off and you do it at home, nobody is knowing whether the person has capacity to do this or not. And to your point, ma'am, about, I am an only child, but I have been told that siblings don't always get along. Is that true? I'm not totally sure, but that's what I've been told. And a power of attorney is your opportunity or the person's opportunity to say, hey, this person is going to be in charge. If they're the oldest, maybe they're the youngest, maybe they're the wisest. Who knows, right? But it's the person's opportunity to name someone, that person's going to be in charge. If you don't do that, there may be some sibling rivalries which rear their ugly heads. This is especially true, we haven't started to talk about it yet, but for healthcare decisions. Now, as I said before, mentioned guardianship. That guardianship mainly becomes necessary in the financial context. That's the most common reason when there's no one to manage financial affairs. For healthcare decisions, the law makes a decision for us about who's in charge. The statutes, Washington statutes say if you can't make your own healthcare decisions, right, and the doctors are always going to look to you first. I don't care whether it's blinking your eyes, yes, once for yes, twice for no, wiggling your ears. They really want to know the patient's opinions. But if the patient can't make their own decisions, the spouse is the next of kin. If the spouse can't do it, then it falls to the children. Well, what if you have 9 children? They all must agree. So, good luck with 9 children, right? And so that is when it can become problematic, and that's why even though the law does name a next of kin to make decisions, it's important that you name somebody to be the primary, and like I said, having a backup and a backup after that. Yeah?
For instance, could I have my daughter and my husband? What if we both got in an accident, and we were both dead? I mean, not dead.
Yes. So her question was, how does she name like her husband and her daughter? You can name co-agents to act together or independently. I will say it does become a little more problematic, but that's where I talked about successor agents. So the document may say, I am naming my husband to be my first agent, and if he can't act, then I'm naming my daughter to be the second agent, and if she can't act, then I'm naming my sibling Joe to be my third agent. Right? So they don't act together, they're acting in succession after each other.
So, to follow up on what she said, can we have our son and daughter, let's say, as power of attorney?
So you can name co-agents,
yeah.
And different people have different philosophies, different attorneys have different philosophies on this. My personal philosophy is it depends on the situation. If your children are best of friends, never disagree, never have a problem in their lives, maybe it's okay. And that might be the case. That is not always the case, and I think I have seen many problems. If you name your daughter and your son as co-agents and they disagree, then you're really stuck. And that sort of goes to trying to work in all the questions here. What happens if you believe one of the agents is not doing their job or stealing money? Go see a lawyer. A little self-serving plug there, but no, there are things that can be done to undo it, but to certainly stop the power of the agent from acting.
It freezes their capabilities once it's...
There are statutes that allow you to freeze their capabilities of acting. It's called the Vulnerable Adult Protection Act in Washington. It's a pretty serious action. And you would need some evidence. You can't just march into court and sort of freeze things. But you can take actions in the court if you believe someone is engaging in nefarious activities.
You briefly mentioned something about freezing of credit. Is that a wise thing to do, period? And
So you can call one of the big 3 credit agencies or all of them, and if you believe that someone is subject to identity theft or is spending money when they shouldn't be, you can call and put a free. If they are not capacitated, right? If this is a person who has advanced dementia or otherwise has a brain injury, and you are their agent, you have to be their agent under the power of attorney or a guardian. You can call and freeze their credit, and when they apply for credit, the credit report will come back as saying, can't do that.
okay.
And that often happens when people have, not necessarily in circumstances where people are incapacitated, but when they have their identities stolen. You can freeze your own credit and then turn it back on later if necessary.
You can do that on credit cards too, like if you, with the banks, you could do that with the power of attorney.
Yeah, that is true. So I should say for all of these documents, the originals really matter. The banks can demand to see an original document. So when I execute these documents for people, I tell them, do not doodle on your originals. If you want to change your agent, you have to actually go back in and make the change with the same formalities of execution that you executed the original document. So it has to be an amendment that is notarized or witnessed. It has to be a whole new document. If people's names change, say that someone gets married, they have a new name, that does not affect the usefulness of the document. You can simply, they can say, have proof that, hey, this was my old name, this is now my new name. You can put a sticky on the document instead of writing on it that says this is their new name. Same thing goes for changed addresses or phone numbers. We like to put contact information on the front of the face page of these documents. People always worry, well, my address changed, I moved. It's not accurate anymore. It doesn't negate the effectiveness of the document. You should just put a little sticky note on the front and no doodling on them. I see that more than you'd think. So I think we already talked about the consequences of no healthcare power of attorney. So along with the healthcare power of attorney, I always like to see people execute a healthcare directive. This goes by many different names: healthcare directive, healthcare directive, advanced directive, physician's directive. They're all different names for the same things. Many of you may have, in the olden days, this was referred to as a DNR, right? It was pretty simple document. It said, yes, take extreme measures. No, don't take any extreme measures. Well, doctors eventually were like, what does extreme measure mean, right? There wasn't a whole lot of guidance in these documents. Modern documents have evolved quite a bit. You can make much, much more nuanced choices about how you want the end of your life to go. And this document, the healthcare directive, it works hand in glove with your healthcare power of attorney. Your healthcare power of attorney, that's the document that says, hey, I'm naming my daughter to be in charge of my healthcare if I can't handle it on my own, or my spouse, or whoever. The healthcare directive, that is the agent's playbook. That is what they look to make decisions about how your healthcare should be handled if you can't make those decisions yourself. So the power of attorney gives them the authority to make the decisions. The advanced directive, that is a document that tells them exactly how, that's your choices, how you want to be treated. And like I said, the modern documents can be very nuanced. So people care about different things, right? My mother, she was a librarian, essentially. And the thing that was most important in her life was books and reading. And she really didn't give rat's ass, pardon my French, about her body. She was like, if my mind is good and I can still read and understand a book, I want to be here. I come from a little bit different perspective. Yes, I care about my brain and I like to read books, but I like being outside. And if I can go for a walk in the woods and I could still enjoy it, I probably want to be kept around. And so you can make those kinds of distinctions in a good healthcare directive document, right? You say, if I have dementia, I can no longer meaningfully interact with people around me. If I can't read a book, I'm out. I can say, hey, if my mind is shot, but I can still clearly go outside and walk around and have a nice time, I want to be around. So I also always encourage my clients, people who are doing advanced directives, we have it's often a guided decision-making form, right? It's going to ask you some questions, going to have some boxes for you to check. I really encourage you, if you're doing one of these documents, to do it with the person who is going to be your healthcare agent. To look them in the eye, talk with them about the choices you're going to make. Have that eye-to-eye conversation, right? When I was doing this with my mom unfortunately did become very incapacitated and could not handle her own healthcare decisions. But I didn't even need to use the advanced directive we'd done because I knew we went over the document together. We had a conversation about it. I knew what was important to her from when she was talking to me. She's like, look, if I can't read an article in the New York Times, I'm out. So I think it's really important. I always encourage you, sit down with your person who's going to be your agent and go over this document. Go over the choices that are important to you. So in Washington and in most other states, we also have a document that is similar to an advanced directive that is called a POLST. Has anybody heard of this before? Bright green form, right? So it is similar to an advanced directive, but it has a slightly different purpose, which I like to point out to people because I think it's an important distinction. It is green, and almost every state has some form like this. In Washington, it happens to be green. It is a physician's order, so it is I can't prepare this. A doctor has to sign it, just like a prescription, right? The purpose of this document, as opposed to the advanced directive, this document is really designed for first responders. So if the paramedics come to your house and you are unconscious on the kitchen floor, they do not know whether you are choking on a hot dog or whether you have had a massive stroke. And even if you have an advanced directive filled out and they see that advanced directive, they aren't going to stand there and be like, page 1, page 2, what does it say on page 3? Does that signature their signature? They are not going to make that decision, right? They are going to act, and they will do everything in their power to save you. The POLST, that is a statutory document. It's adopted by the legislature. The first responders are trained with this document. They're familiar with it. It's a very simple document. It's much more like the old DNR orders. Yes, do everything. No, do nothing. And the reason it is slightly different and may have different choices from your advanced directive is that if they come into your kitchen and you're unconscious on the kitchen floor and you're choking on a hot dog, you probably want them to save you. So you may say on your POLST, yes, do everything, get me to the hospital, and when you get to the hospital, the doctors can then use, and your healthcare agent can then use your advanced directive to make a more nuanced decision. Maybe on the way there, they've plucked the old hot dog out, and you're like, oh, whew, that was bad. But maybe they get there, and you're like, oh, you've had a very big stroke. You're no longer going to be able to meaningfully interact. Then you use the advanced directive, and the advanced directive may say, don't take any more measures. Take me off life support. All right. I think we talked about those things already. Yes?
I'm caring for a cousin with Alzheimer's. He's 86, I'm 82. He has a POLST, fortunately, signed DNR, but his advanced care directive that has the nuances is in the hands of his financial P of A and his brother, neither of whom has been willing to share it with me. What alternative do I have?
So the person who is named as the healthcare, if they're just the financial POA, that does not mean they are in charge of healthcare. The power of attorney should be specific about what powers the agent has. If there's no healthcare power of attorney, as I noted previously, it would fall to the next of kin, and that would be either one of his children. If his children are not around and his parents are not around, obviously, it would fall to his siblings, plural, or sibling individual if there's only one, to make those decisions. And frankly, they're not obligated to share it with you. Now, if you feel that is a detriment to the person you are caring for, I think the first thing to do is to talk to them, to say, if you are the healthcare agent and I am the one who is caring for this person, I should know what the choices are, and at least be able to contact you to let you know to make those decisions. I should also add at this point, I don't know if I said this previously, but you should give a copy of your healthcare power of attorney and your advance directive to your physicians or physician, whichever you have plural. And if you have a hospital that you are most likely to go to, maybe giving it to their medical records department. I'm up in Whatcom County. I say we are cursed and blessed. If you get sick in Whatcom County, you're going to a Peace Health institution, whether you like it or not. Peace Health is a healthcare organization. And so it's very easy because everybody in Whatcom County can send their healthcare directives and healthcare powers of attorney to the Peace Health Medical Records Department. They will scan them in, and then when you go to the ER or you get admitted to the hospital, it's right there in their medical records that you have these documents, and they will be able to follow them. All right. So, how am I doing on time here? Okay. So let's talk about wills briefly. Yes, everybody probably should have a will. If you die without a will, so dying with a will means you have died testate. You often will hear these words. If you die without a will, is considered dying intestate. And if you die without a will, it does not mean that the state gets your money. That's an old wives' tale. If you die without a will, your assets will go. Your creditors need to be paid, obviously, but your assets will flow basically in the same way the next of kin statutes are laid out. Right? If you die without a will, it first goes to your spouse. There are some nuances to this, especially if you've been remarried and have children from other families. But it goes to your spouse. If you have no spouse, it goes to your children. If you have no children, it goes to your parents if they're alive. If you have no parents, it goes to your siblings. There's a tree that the state has laid out about how your assets will pass. The will is really a dormant document. It doesn't mean anything until you actually pass. It just sort of lies there sleeping. It can be changed at any time as long as you are competent. The will only gains authority and gains any meaning when it is given the sort of imprimatur of the court. When you take it to court and the court says, yes, this looks like the actual will, it looks like a valid will, the court signs it, and whoever is named as your personal representative, that's the modern term for executor. I don't know why they changed it. I liked executor. I think people they were uncomfortable saying executrix, maybe. I don't know. Yeah, I don't know. So the personal representative, they will get letters testamentary. So this is the little sheet of paper, essentially, from the court that gives the personal representative authority to go out and start handling the affairs of the deceased person. And a lot of times if you're trying to handle especially their financial affairs, a bank's going to say, oh, I need to see your letters or your letters testamentary. And that is what they're talking about. It's the document from the courts. Now, I will say at this point that probate is often considered a dirty word. We've all heard terrible stories about probate. Everybody here has read, well, you may have read Bleak House, right, the old Dickens novel. Probate in Washington should not be considered a dirty word. Probate in Washington is a pretty streamlined process. It is not crazy expensive. Yes, you have to use a lawyer. Yes, it's going to cost some money. But it is not a terrible process. And it's not going to be tied up generally for years and years and years. There are always exceptions, but generally it will not be tied up forever. If we were in California, we'd be having a very, very different discussion. The probate laws differ significantly from state to state, and California is a pretty onerous probate state. But we are lucky here in Washington. If you have to go through probate, it's not a big deal. All right. So, trusts. Everybody always has questions about trusts. So, trusts, there are many, many types of trust. I mean, as many types of apples as there are in Wenatchee, that's how many trusts there are. You can just go on and on and on and on. People in California wouldn't get that joke. The one where most people are most commonly talking about is the revocable living trust. It's a trust you create during your lifetime to hold your assets, your real property. You can put bank accounts in there. You can put cars in these. You title them in the name of the trust. So the trust is actually the owner of these documents. The trustee, which if you create the trust, you are most likely going to be the trustee. You're in charge of the trust. So it's your stuff that you put in the trust and you're in charge of it. It's just sort of creating this separate vehicle that manages your, no pun intended on vehicle, that manages your assets. Now, why would you do this? In some states, like California, lots of people have trusts because it is a way to avoid the probate process. In Washington, it is often more difficult to administer a trust after someone dies than it is just with a regular probate. I will say the trust administration when you die is a private affair, so you don't have to use the courts at all. If you do have to use the courts for the probate process, the will does become a public document, unless you're somehow able to get it sealed. And certainly, you know, if you're a prince or you're a famous person, you might want to avoid the public eye and have them know where your stuff is going. Actually, Prince, I believe, died without a will. Fun fact, I grew up about 5 blocks from where Prince went to high school. But you know, for me, I'm not really going to care if anybody can go see my will. It's going to be a public document, big deal. Historically, people have also used revocable living trusts for tax avoidance, avoiding estate tax. It can be a way to do that. I will tell you that most of us now will not have to worry about estate tax. In Washington State, the estate tax begins once you hit the it's just over $2.1 million now. Anybody know where the federal estate tax is going to begin next year? Yeah, I think next year it's going to be 11.6. And if you're married, you get to double that. So if you have a federal estate tax problem, come see me afterwards and you can go buy me a drink. How's that? Because you can afford it. It's afternoon. It's going to be afternoon, so I can have a drink then. So tax avoidance, it can be used for tax avoidance, but it's not a huge deal. Another reason, probably more common these days, is modern families. Remarriages, people bring their own kids and their own assets to a second or third or fourth marriage, and they want to make sure that their assets go to their kids and the other spouse's assets get to go to their kids or some other variant of that. And a trust is a way you can do that. A trust is a way you can control your assets, sort of the hand from the grave that controls how your assets flow after your lifetime. Lastly, I will mention, and I always like to make sure people know about this, people with disabilities, people who are on public benefits, who have SSI, or maybe even SSDI sometimes. These are what happens when you become disabled and can no longer work. These are benefits, and this includes Medicaid, which can be used in circumstances for long-term care. If you have someone in your life who has a disability and is on asset-tested public benefits, very important that you consider not leaving them money directly, because it will spoil their assets, right? Maybe they can only have SSI, you can only have $2,000 to your name. And you get $750 a month now if you have SSI. And maybe you get left $50,000. We think, oh, $50,000 bucks, big, it's a good, nice little chunk of money. The unfortunate part is not only do you lose your $750 a month, but you lose the health care that goes with it. If you're on SSI or SSDI, sometimes you will get Medicare and Medicaid. And so if you have someone in your life with a disability, important that you consider something called a special needs trust. It's a type of trust that money can go into. If you're leaving somebody money in certain circumstances, you can put your own money into this type of trust. And it essentially becomes invisible to the people who administer the public benefit programs. And so you can remain on the benefits and have the benefit of having the money that's in the special needs trust. There is a difference, very important difference, between whose money is it. As I said, say you inherit money, right? And say you inherited $50,000 and you were under the age of 65. You wanted to keep your benefits. You could put that money in your own special needs trust. But it is better, and this is why I talk about this as part of planning, if you have someone, a son or daughter, say for instance, who is on public benefits, and you leave them the money in the special needs trust in your will, say for instance, it never goes to that person directly. The money that doesn't go to them directly, it is safe forever. And if the person who is the beneficiary passes, the money then flows to whoever you've directed in the trust. So say that they die, your son or daughter dies, God forbid, with another $40,000 left in the trust. The money can then be directed to your other children, say for instance. If, however, no provisions are made, the money goes, say I was on SSI, my mom passed, she left me $50,000. I didn't want to be kicked off of my SSI if I was on that. If I was under the age of 65, I could put the money into a first-party special needs trust because the money became mine, right? My mom left it to me directly. She didn't leave it to me in a trust. So I could create my own trust. The trick here, and the reason the state lets you do this, is that if I were then to die with money in that trust, the state would get the first crack at the money. So the state's been spending money on my behalf all this time, right? On medical expenses, they've been paying money every month to me. And if I die and there's money left in the trust, before it goes to somebody else, the state gets to come in and say, hey, I'm getting some of that money back. All right. So, well, that was good. I'm within a minute, I think. Questions? Yeah.
I have a question concerning annuities that can be brought out when you can not take them until you're 85 or 90 years old. Would that help in the event if you don't have any insurance, and if you don't have any type of long-term insurance, your spouse has to go into something, and if you're the only one on that list, then you would get the money and then it would be taken by the government?
Sure. So, gentleman's question here was really about a little bit about how to pay for long-term care. And the situation was, say that your spouse needs long-term care, and you know that there are limits on how that can be paid for by public benefits. Medicaid is now a huge program, right? Under Obama, Medicaid now it's a huge umbrella. We're talking about a very specific type of Medicaid, long-term, post-65 long-term care Medicaid, and it can be used to pay for long-term care. But the rules are very, very strict. It is, as we were just talking about, an asset-tested public benefit. With that, like I said, we could spend all day talking about this, but the basic rules for Medicaid are, if you are single, you can have no more than $2,000. So you have to basically spend down all your money. You can own a house and you can own a car, but in terms of liquid assets, $2,000. If you are married, they look at the assets of both the we'll call them the ill spouse and the well spouse. Depending on what sort of care you need, if you're in a skilled nursing home, and skilled nursing is a very particular type of care, we're not talking about memory care. Memory care is not skilled nursing. So if you go into memory or you go into skilled nursing, there's a possibility you can keep somewhere that both spouses together can keep somewhere between about $56,000 and $127,500 or $128,000. So you have to manage about how you have that money. Your question particularly was about annuities.
Is it one that you can't take until you're 85 or 90?
Well, I don't know what particular. So he asked about an annuity that you can't take until you're 85 or 90.
It's an extended age annuity that is not that you cannot touch or take any money out of until you're 85 or 90.
Yeah.
And I wondered if that's protected.
I'd have to look at the annuity. Really, the only type. I haven't seen that, so I'm not going to say for sure. Really, the only type of annuity that is protected is something called a Medicaid-compliant single premium immediate annuity.
Can you repeat that?
Yeah, we'll just call it a SPIA, single premium immediate annuity. Single premium immediate annuity. This is really something you need to see an elder care attorney about. And this is something that the well spouse would take out. So if my host would indulge me for about 3 more minutes, if that's okay, I can sort of explain how this works. It's a little slice of paying for long-term care. So the most basic situation is one spouse comes to see me, the other spouse needs to go into long-term care, and how are we going to get them qualified to pay? First off, I will say that if you are going into memory care, you usually cannot get on Medicaid right away. Even if you qualified, the facilities will require you to privately pay them for a couple of years at least. In Whatcom County, we're seeing 24 to 36 months. Other places, you're seeing 36 to 48 months sometimes. And the reason they do that is because if the person goes on Medicaid, Medicaid makes them take a pretty serious haircut. If you're private paying maybe $6,000 a month, and they go on Medicaid, Medicaid's only going to pay them maybe $4,000. So the facilities know that they have to get their profit up front, because once you go on Medicaid, they aren't going to make very much money. And they aren't under the same regulations as nursing homes. Nursing homes are required to take you on Medicaid right away. So, going back to the situation, you come into my office, you say, hey, my spouse has been at this assisted living facility for just about 24 months, and they say they'll take Medicaid. How do I get qualified? What we would probably do, if you owned a house, the house would be exempt. They don't count the house. But we would make sure that the house gets into the well spouse's name, because if the ill spouse dies, the ill spouse goes on Medicaid, and then they die, and their name is still on the house, the state can put a lien on the house for the amount of care, the amount of money they've expended on that person's care. So one step is we often put the house in the well spouse's name.
You can do that even after they've gone in?
If you have a power of attorney. It sort of ties back to what we were, thank you, you just made a nice little loop for me there. So if you have a power of attorney that authorizes you to sign on behalf of your spouse, you take it out of her name and you put it into your name alone. The other thing we would do is we would probably move all the assets out of the ill spouse's name. We'd put them in the well spouse's name, right? What happens if the well spouse has, say that you could only have $56,000. It's an approximation, but say that's how much you have, but you actually have $356,000. What do you do? And your house is paid for, you don't need to buy a new car, everything's taken care of. What do you do with that extra money? You can buy what's called the single premium immediate annuity. Okay? The state lets you do this. It's a perfectly legal way of doing it. And the single premium immediate annuity, it pays you back over 5 years. So we're going to take our mythical $300,000. You've had $300,000 too much. What do you do with it? You buy the annuity, and it starts to pay you back immediately. I picked $300,000 because I'm really bad at math, and 300,000 makes the math really easy. It's going to pay you back over 5 years. That's $5,000 a month, right? If you live out, if the well spouse lives, and once it goes into the annuity, it's sort of invisible for Medicaid purposes. The state says, oh, it doesn't count. And you'll see why in a second. So the annuity starts to pay you back. You're getting $5,000 a month. Once you get through the Medicaid application window, so you've put the money in the annuity, you now have $56,000. Medicaid says, yep, your spouse is now eligible. You get her on Medicaid. The day after she gets on Medicaid, you can hit the lottery. And the well spouse could hit the lottery, and it doesn't matter. Okay? So you start to get this income back from the immediate annuity, and at the end of 5 years, you've gotten all your money back. Great. Things are good. But if you die, before the well spouse dies before the 5 years are up, the state gets the first crack at the money that's left in the annuity. That's the risk, that's the price you pay that the state exacts for letting you put the money in the annuity. Otherwise, you wouldn't qualify for Medicaid at all. Okay? I will say this is not a traditional annuity in the sense this is not going to be a good investment. It's not going to make any money for you. It's simply a place you can park the money to make it invisible for Medicaid purposes. But it is a very good option when you have too much cash resources.
I know in Oregon, and you mentioned California, the laws, I don't know what they differ. In Oregon, what the laws differ, if you have any experience with that, because you mentioned California, but also they have the right to die there as well. And my stepmother actually had to divorce my father, and we weren't aware of that yet because we didn't haul him out the minute she told us he had this, because it came on so sudden in the end, once we were aware. So she just, went hog wild, and she was actually divorced from him to protect the assets in Oregon. And so I'm wondering if there's anything to hold her accountable for that in any way, too. Not that but she had dispersed his physical assets while being divorced, and you can't do that. So
well, I can't comment really on the specific question. Divorce can be an option to separate out assets if you get a court order.
Children, they separate the children, right?
It gets sticky, and especially if one spouse is not fully competent, right? It gets very difficult to get a divorce in that case. Divorce can be an option. I'll be honest, in my practice, almost no one ever wants to get a divorce, right? People have been married a long time. They're like, I'm not getting a divorce. We'll figure out a way to deal with this in some other fashion. So I will also say one important piece I didn't add. We talked about the financial qualifications less than $2,000. Important to add, you can't give your money away, right? When you apply for Medicaid, one of the questions they ask you is, have you made any uncompensated major gifts in the last 5 years? So don't run out and give all your money to your kids thinking that will protect it from Medicaid.
David, thank you very much.
You're very welcome.
Here. Thank you so much.
Thank you all.